Hi, good afternoon everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. Today is December 14th and this is our community conference call every other Thursday. Let me get started with the questions that I have marked as frequently asked questions first. I'll invite follow-up questions, after which I will take on the routine questions, and if time permits we might take on new questions. I doubt that we'll have time, but if there is time within the hour we'll take new questions, otherwise we'll stick to the ones that have been posted. The first frequently asked question is, does bad credit or private loans or litigation affect immigration? And the general answer is no. Unless you owe money to the government, US government specifically, just because somebody sued you, you had borrowed money from some guy and he sued you, or there's a litigation going on, there is a bad debt, any of those things should have no effect on immigration, whether it is H-1B, L-1, any kind of visa or green card. Private immigration, let me rephrase that, private litigation, private loans, unless they flow to the government or have some criminal implication somewhere, should have no issue. The question has been posted by Sanjay Mishra. He says, I'm a UK citizen. I had taken a bank loan when I was in UK, but I did not pay it back. So I've got a bad credit in UK. Working in USA for 2 years, my current employer doesn't know about this bad credit situation. But Mr. Ji, I don't think that should be a problem. Unless that non-payment of loan was somehow some kind of a crime in the United Kingdom. If it is not a crime, I don't see why this is an issue at all. Folks, anybody who has a follow-up question on this issue, press *5 on your phone, please. Press *5 if you have a follow-up question. Okay, let's take on the next frequently asked question. Now this one I actually combined two questions. I think they are from the same person with different names, but anyhow the situation is quite similar. It's a frequently asked question that covers various elements of changing jobs after the I-140 approval, including can I go back to my old job? So let's get over these one by one. These are important questions. These come up quite frequently. First one is, I am on H-1B visa from 2008 with employer A. I-140 was approved back in 2011. Now I want to change to employer B. So first scenario, if employer B doesn't start my green card in 3 years, can employer B use employer A's I-140 to renew n number of times? I guess what you're saying is the H1. So right now the law is your I-140, once it has been approved, and in your case it's been approved for more than 180 days, you can definitely use that I-140 to keep getting your H1 extensions through any employer. Okay. If I did not like employer B in future and they haven't started my green card, can I switch to employer C? And the answer is still the same, which I told you. Using one employer's I-140 approval, you can join any employer or any number of employers to extend your H1 beyond 6 years. Scenario 3. If I did not like employer B in future, can I go back to employer A? I guess that's what you're asking, right? And they have not sponsored. Then I switch to employer A. They don't have to start your green card over again. There is only one problem in this whole scenario. If you look at the situation academically, See, I have two hats. One hat is of an academician who looks at the theory of the law, and the other hat is that of a lawyer who looks at the practice of law. If you look at it as an academician, this can be a problem, and they should start the green card all over again. Why? Because the basic jurisprudence, the legal theory of a green card is that there must exist a job that continues to exist without interruption. So when you leave the employer A with an intent not to come back, or the employer no longer has the intent to hire you back, it can be argued that the continuity of the intent of having a job that the employer wants to give you and that you want to accept has been interrupted. There's actually a case like this. Many years ago, there was a restaurant which had some green cards going for their employees. The restaurant got bought out by another company, and the company closed down the restaurant for renovations, I think for 3 months or a month, something like that. But during that month, they terminated everybody's employment, and once the renovation was complete, they hired everybody back. And at that point, it was held that because of the interruption, the termination of the employment, those green cards are all gone now. They have to be started all over again. Now, if this employer had not terminated employments, even if they hadn't paid them, it could very well be argued that those green cards go on. So I guess employer A can definitely start from where you left, as long as there was an intention to keep the job open and for you to come back, which I think is difficult to argue in your case. You should talk with your lawyers. I am very, very careful with immigration law. I have been very careful for years, and I can tell you this, that really paid off a number of times. I was in court last Monday, not this Monday, but the last Monday, as an expert witness. And we went into details like, for instance, I pointed out to the court that there exists no regulation about how a corporation is supposed to sign H-1B forms. There's no regulation directly affecting that. So you can go into all those nitty-gritty details once you get into courts. So therefore, because all these forms are filed under penalty of perjury, you need to be hyper aware of what you are signing and what the employer is signing. Theoretically, it is possible to go on. As a practical matter, it may be smarter to restart the green card. Okay, I think that would be really the cleanest option. If I were the lawyer representing the company and or you, I would recommend that, unless there was really an ongoing intention to join back. Okay, sometimes it can happen. I've given this example many times, that you wanted to learn new technologies, or you wanted more exposure, you change jobs, better options, then you realize, no, I want to go back. You hadn't decided that you were never going to go back. You wanted to leave that option open, but you also wanted to explore other options. I think there's a very good case to be made that you never left the intention to join back. And that is the problem. Then, scenario number 4, how much of overlap of dates of employment can happen between employer A and employer B? Now, I'm not quite clear what you mean by that. Remember, in order for you to work for 2 employers simultaneously, you need a concurrent H1. You have to have a special kind of an H1, which is called concurrent H1. You cannot work simultaneously for 2 employers. Then the next set of questions was, and I'm not sure if it is the same gentleman or a different gentleman, I'm on my 7th year of H1B. I-140 has been approved in Feb 2017. No, I think it's a different gentleman. It is currently in approved status with 180 days passed with employer A. Now I want to go to employer B. After I move out, employer A would anyway revoke my approved I-140. Will my I-140 be in approved status even though employer A has revoked? Yes, that's what the January 17th regulations say. The January 17th regulations say that once the I-140 is approved and stays approved for 180 days, thereafter, even if it is revoked, you have the right to keep extending your H1 with any employer as though the I-140 was still alive. Your wife has or your husband has, on H4 has the option of renewing the EAD, H4 EAD. So you get all the benefits. The benefit of keeping your priority date becomes yours the moment the I-140 is approved. So revocation has nothing to do with it. The only time you lose these benefits is if, number one, the I-140 is revoked for fraud or revoked for erroneous approval. So government says, oh, we approved this in error, we are going to revoke it. Then you don't get any of these benefits. Next one is, can the new employer transfer my H1B, apply for H1 extension when A has revoked? Of course. When should employer be immediately filed for my green card paperwork? Yeah, I-140 itself forms the basis for extensions. Green card is there to pull you into the green card status. As far as your H1B is concerned, that can be based upon the prior I-140. It doesn't require a separate green card filing. At what point of time should employer be start my green card paperwork? I would say as quickly as possible, but there is no huge hurry because you've got your I-140 approved for 180 days. It's going to keep you safe for a very long time. So if the employer didn't want to do it for 2 or 3 years, they could potentially delay that. Now with approved I-140 from employer A, now somewhere in the back of my mind there is a regulation that says if your priority date becomes current, maybe the situation changes. I don't remember exactly that regulation, whether that was implemented or not. See, most people have a very backed up priority date, so we don't really have to look at that law. But if you end up having some delay in filing your green card, have your lawyers review the regulations and make sure there's nothing that says you've got to get the second green card started before the priority dates become current or something like that. There was something, I don't recall exactly what was there in the regulations, but I remember reading the proposed regs and there was something there about priority dates becoming current. And then the I-140, I think, cannot be used for 3-year extensions, only for 1-year extensions. That is the law anyway, but you should take a look at it. I don't remember the interplay of the regulations. As long as the priority date is not current, you can keep getting extensions based upon the I-140. At what point of time, okay, now with approved I-140 from employer A and without employer B starting my green card process, can my spouse work on H4 EAD if my priority date becomes current? Let's try to remember what the regulation is. I don't think that should be a problem, but look, I have to read these regs. I don't remember all of this off the top of my head, but I don't see any immediate problem. I'll have to go back and look at the regulations, what they say about H4 EAD in case the priority date becomes current. As I recall, the H4 EAD was available under the circumstances where your H1 extension beyond 6 years was going on. Now, if you become ineligible to receive that for some reason, I don't see why, because you still have 1-year extension possible. I'm just thinking out loud. I frankly, I don't remember what the regulation says about H4 EAD. But definitely moving over to the employer B is not a problem. Now, this is all the H4 EAD questions. I-140 questions. Does anybody have a follow-up? Please press *5 on your phone if you have a follow-up question. I've got 2 follow-up questions. Let's take them one by one. Which one did I just unmute? 1 second. There's 3 follow-up questions. I have unmuted California. California, go ahead, please. California.
Hello, sir.
Hello, sir.
Good afternoon.
Good afternoon.
So this is regarding that questions I posted for the second half of that follow-up question. So, excuse me. So if the employer, can the employer withdraw the firm at any time? Saying that there is still error.
Once your I-140 is approved and stays unrevoked for 180 days, there's nothing that the employer can do which would affect you. At that point, The only way you can be affected is through the government action of revocation based upon erroneous approval or fraud.
Okay, thank you. And one other question. So you said like the H1 extensions can happen any number of times, which means, so I got a 2-year extension with employer B after I moved to that company with employer A is approved 140. And when it's up for renewal for the next 2 years or 1 year, they can still use the approved I-140. The employer B can use it, correct?
That is correct. Yes, sir. Okay.
Thank you, sir. That's all I have. I think you answered most of the questions.
You're welcome.
Thank you very much.
You're welcome. Good luck. Okay, let's select the next person. And this one is from...
Hello, Raj, sir. I have one more follow-up question on I-140.
Yeah, go ahead, please. I'm just trying to see. You're also from California. Go ahead.
Yes, sir. Yes, sir. I'm also from California. And I already posted my question.
Okay.
My ID is Prasad 99. Is there a possibility? Can you go and look into that, or else I can read that question?
No. I'm going to take all the questions in line. I'll get to your question.
Oh,
right
okay.
now, I just said if you have a
sir.
follow-up question.
In that case, I can wait.
Yeah. Please wait, because I'll get to everybody's questions that have been posted. Those I'll take care of. Don't worry.
Thank you. Thank you very much, sir. My question is also related to I-140. That was the reason I interrupted. Sorry for that.
Okay. Now, which question number is that? Do you know the number?
That is 11, sir. Share 11. It is showing in your website.
Okay.
Share 11.
Let me just see. Because if it's related to the same thing, yeah.
Yes, sir. Related to the
Prasad
same.
99. I'm on H1B.
Yes, sir.
I-140 approved a year ago. Current employer refused to share the I-140. You filed the FOIA. Under that, you got a copy of the perm. You got a copy of the I-140 application form. You got the LIN number. You didn't get the I-140 approval notice. So with these available documents, can I do an H-1B transfer? Absolutely no problem. Okay. So even though you don't have the approval notice, you have enough documentation to show that you have a case number, etc. We've been able to do it before with just a receipt. So you certainly have all that information. So I think you should be fine.
Sir, except notice copy, I-797 notice copy, I have lien number and the priority date.
Right.
Even I took the info pass from US. They shared my A number as well.
Right.
And they told me I-797, which is employer property under Privacy Act, they cannot share. But through FOIA, they shared all the information.
Right.
So currently I'm in 6th year. So I can go with a new employer beyond my 6th-year extension, right?
I don't see any problem with that. Okay. So as long as your I-140 was unrevoked for 180 days, the fact that you don't have any evidence of it directly is not a problem in my experience. We've been able to get these cases approved, H1s approved without the approval notice of the I-140.
I'm sure my 140 is not revoked, sir, because 4 months back my wife's H4 EAD also approved, and my employer supported for her H4 application process, and she got the H4 EAD as well.
Then you should be fine. I don't see any problem.
Okay, sir. Thank you very much, sir. Thanks for your time. I appreciate it.
Good luck. Okay. Now, is there one more? 1 second. No, I think we are done here. Okay. There's another one. Give me 1 second. I'm having a little bit of trouble keeping track of. There appear to be 3 more people hands raised. Okay, let's try it one by one. All right. This one is also from California. I think back to this first questioner. Go ahead, California.
Hey, Raju, this is Ram. I have one question on this I-140. So, I'm with current company A. They filed perm and it's got approved. in 2014, and parallelly, one more company, the company B, they filed perm, and it's got approved the last month. So is it mandatory to join company B, or like they're asking to join like before filing I-140 with a company B?
Well,
so is this mandatory or how is that?
Mandatory in terms of, does immigration law require you to join a company through whom you have your perm approval? So no. For filing an I-140, joining the company is not a precondition. No.
Okay.
Okay.
Okay, so they can continue, they can file I-140,
If
company
they
B,
want
they
to.
can file I-140.
Yes, if they
No,
want
no
to.
need to join.
Right. There's no need to join. There's no such law. All that is required
Okay.
is that you have a good faith intention in the future to join them. When is the future? The future is either before the green card approval or reasonable time after the green card approval.
Okay.
It's based
Okay.
upon intention.
Thank you, sir.
As long as you have the intention, you actually don't have to join them. It's a very odd law, but that is
Okay.
the law. Okay.
Got it. Thank you, sir.
Good luck.
Appreciate it.
You're welcome. Okay. Let me hope so I don't screw that up. Give me 1 second. All right, this one I got. Now we've got another one from, this is from Illinois. Illinois, go ahead, please.
Hey, Rajiv, I had the same question.
Right.
So you said once the I-140 has been approved for 180 days,
Right.
the employer cannot withdraw it or revoke it. So what if, let's say my 485 was filed and it's pending for 2 months and I change employers. So at that time, can the employer revoke I-140 or?
Okay.
And would it impact my AO?
Let me first of all rephrase what you said to make it legally more correct. Employer can revoke it, it just doesn't affect you. Okay. So after 180 days, revocation of the I-140 has no practical effect on you. Your priority date is safe. Your right to to get your H1 through any employer is safe. Now, the regulation about, or the law about I-485 pending for 180 days is a different law. That comes under American Competitiveness in the 21st Century Act. There, the law is, once your I-485 has been pending, I-140 is approved, and I-485 has been pending 180 days, the employer can do nothing to hurt you as long as you can get a same or similar job, same or similar to the perm job or the green card job that you were supposed to get anywhere with any employer in USA. So that's a slightly different law. The I-140 law is a slightly different law. Both rely upon 180 days, but there are different consequences. In the I-140, you are just protecting your priority date and H-1B. But in the 485 context, you're protecting your whole green card. You don't have to redo the green card. Okay. Does that make sense? No. Hello?
Yeah, so you said even if I leave the employer after 3 months, let's say 90 days, and if I can find a similar employment as for the firm, I should be okay?
Well, here is the law. The law is, as long as your I-140 is approved and 485 stays approved for 180 days, you're not going to get hurt as long as you can get a same or similar job. So let's take this example. You filed your I-485, your I-140 is approved, you filed your I-485 and left 2 months later. Let's say that for 4 months you got no RFE from the USCIS. In 4th or 5th month, after 180 days of your I-485 pendency, you got a letter from the USCIS saying, prove that you have the same or similar employment. No problem. The fact that you left before 180 days is not operational here. What is instrumental is the fact that your 485 stayed approved for 180 days. So even if you leave after 2 months, that's not going to hurt you. The law doesn't require you to stay employed with the same employer for 180 days. Just the 485 should stay untouched for
pending.
days.
Okay.
Okay.
Makes sense. Thank you.
You're welcome. Good luck. Okay. So we don't have any other questions on this. Let's move on to the next frequently asked question. Effect of salary variations during L1A visa. Well, L1A visa is a little different than H1 visa. Salary variations are normally not that much of a problem, but if the salary range is very, let me rephrase that, if the salary variation is too much, I think that could become an issue, because L1 laws say that anything that affects the eligibility for you to hold the L1 status requires an amendment. So I can assume, again, there's no law specifically covering this, if somebody goes to the USCIS for an L1A visa for a manager and says, look, I'm going to pay the manager $90,000, but they end up paying the manager $30,000, government could say that's a substantial problem, because if we had known that you're going to give him $30,000, we would have made a common sense objection that doesn't look like a managerial level salary. Even though it is not mandated by law, as a matter of common sense, it could become a problem. So you had a salary of 120. If your salary is 60 to 80, I think that's substantially less. And that would definitely worry me, because I'm not sure that if it's closer to 80 or more, I think you have a better chance. So ideally, you should be paid what has been indicated on the L1 paperwork, but there's certainly no law that I can point to that mandates that result. It's just a general sense of uneasiness because it could go into eligibility. Okay, so and also if your payroll is run with salary plus bonus, I think then you should be okay, because the law is a little bit more forgiving as far as I know. I haven't researched this issue, but the law is definitely a little bit more forgiving in L1 cases than H1 cases. H1 cases, we look at the straight time salary. We don't care what bonus you are getting. But in cases of L1, I don't see why you cannot combine it. Have your lawyers look into it. It's not an issue I can authoritatively tell you. I've researched and I know how it works. But I do know anything that goes to eligibility requires an amendment. Okay. But if you're close to 80, 100,000, something like that, a few thousand off the promised amount may not be a big deal. But again, I would have to look at the law. I have not encountered this situation specifically. Star 5, if you have a follow-up question. Star 5. Okay. Let's go on to the next frequently asked question. So this is also a difficult one. Implication of an alcohol-related conviction such as DUI on immigration or H-1B. So there are two aspects of this that you need to know. First of all, generically, if you get convicted of a crime, you could be deportable unless you are covered by a few exceptions. If the crime is not a crime of moral turpitude, and that's a difficult term to define, you definitely will need somebody to advise you specifically about your situation. Generically speaking, not all crimes have immigration consequences, whether on your H-1B or your green card. Some crimes do, and then there are exceptions. So if you get convicted of a crime of moral turpitude, but for example, you sold alcohol to a minor, that's considered to be a crime of moral turpitude in most states, I think. So in those cases, if the crime was a misdemeanor, which means the punishment was, I think, a year or less, or is it less than a year? One of the two. So if it's a misdemeanor and the sentence actually imposed was less than 6 months, you are covered by something called petty offense exception, which says, okay, we'll have no immigration consequences for you, whether it is your H1 or your green card or L1 or any of the other visas. So firstly, if the conviction is not for moral turpitudinous crime, you may have no consequences. But if it's a moral turpitude crime, if it is covered by a petty offense exception, you may not have a problem. Now, coming specifically to DUIs. So if a DUI is a felony, I think you're going to have a problem, because potentially DUIs can also lead you to another ground of deportation or exclusion. So there are a couple of different issues here. Generally speaking, if you have a DUI type crime, it can affect your green card and your H1B. One, because it is a criminal conviction, and two, government acting through its consulates revokes your visa. If you get convicted of a DUI, they will revoke your visa, which means as long as you're in the USA maintaining your status with the I-94, etc., the visa revocation doesn't concern you. But if you travel outside USA, even though you have a valid visa, it is revoked. You have to go apply for a visa again, go through their psychologist panel or psychiatrist panel to be assessed for intoxication related addiction issues. So it becomes a lot more complicated. I'll summarize again. As a general rule, crimes can become a problem if they are crimes of certain types, including moral turpitude crimes. If they are moral turpitude and there's a conviction, if it is a misdemeanor conviction and less than 6 months sentence imposed, you should be okay under petty offense exception, which excuses one petty offense in your lifetime. For DUI convictions, you can have your H1 visa revoked and you'll have to go through visa again if you go outside USA, but if you're inside USA, that's not a problem. Now, let's look at Priyaj Kumar's situation. Harrisburg, Pennsylvania, taken to custody. Okay. Now, first thing you need to do is when you have a criminal conviction situation, don't be fooled into believing that your criminal defense counsel knows immigration law. They do not. These are very different situations. I had a case of a corporate fraud in Pennsylvania where they told me, the local counsel, of course they were talking from criminal defense perspective, that, oh, this is not an issue, and if you get the diversion, it is not considered to be a conviction. Actually, it was. When I started looking at the law, I look at it from the immigration perspective. So first thing you need to do is definitely need to get an immigration lawyer involved, somebody who does deportations. And I usually prefer that you get somebody local, because somebody like me can do it, of course, but then I have to read the law, the Pennsylvania law. I have to understand their procedures. But if somebody is already working in that state with those laws, they already should know that, and they might be able to advise you better if they are competent. If the lawyer is not competent or experienced, you are better off with somebody who is experienced. Okay, but get yourself, in fact, normally criminal defense counsel themselves reach out to immigration lawyers to make sure they get the right kind of plea. As long as you're not convicted, you're not guilty. So if you are traveling and you have a visa stamp, typically that should not be an issue as far as I know. Now, you're asking me questions about how to get the case dismissed. That's a criminal defense matter. When should I inform my employer? That is also not a domain of immigration law. Under immigration law, I can't comment about that because there's no rule that you have to inform the employer. Can it impact your green card process? I don't think so. As long as you meet the petty offense exception. First, of course, preference would be to get no conviction at all. So if some kind of a deal can be worked out where you don't plead guilty and you do some kind of community service, etc., and it gets dismissed, that would be great. Okay. And that diversionary program, that the one that I looked at under Pennsylvania law, was considered to be a conviction even though local lawyers thought it was not. So yes, coincidentally, I remember that case clearly because that was an ARD program under Pennsylvania laws. So I figured at that time, I don't know if the laws and procedures have changed, but at that time, it sure looked to me like it was a conviction, even though under criminal law it was not a conviction, under immigration law it was. Star 5, if you have a follow-up question on this. Star 5. Okay, let's go on to the next frequently asked question. So this one is staying in the United States based upon medical need of a child, B2 or humanitarian parole. Normally, we've had success where a parent needs to stay in the United States with a child for medical reasons, sometimes even if the child is going to school. We have been able to get a B2 status or even a B2 visa. Now, if a B2 visa is denied, if you're outside USA and B2 is denied, you can try a humanitarian parole. Humanitarian parole, last time I did it, used to require that you must have tried for a visa and the visa was denied and your case had humanitarian considerations. So that's when you can apply for humanitarian parole. In fact, if you do a Google search on USCIS space humanitarian parole, you'll see what the grounds are. Okay. Star 5, if you have a follow-up question. Okay, so that finishes our frequently asked questions for today. Now let us go into our regular questions. First one is from HP2111. I'm on OPT. My H-1B petition is pending status, which was submitted for location California. Meanwhile, I got assignment through new employer in New Jersey and continue working on OPT as my H-1B is in pending status. Once my H-1B is approved, if I decided to continue to work in New Jersey, you'll need to file an amendment. Yes, that is correct, due to new location. So there are two scenarios. Since I'm traveling, once my H-1B will be approved and H-1B amendment is in pending status, can I travel? You can travel, but it becomes complicated to get visa stamping done. So if you are going to do this, please do the amendment premium processing. So I think you cannot use the old petition. It is no longer really your future status. So you should really get the H-1B amendment filed premium processing. That would be the most logical conclusion. And I don't think you can come back on your OPT, because if you've got your change of status, the OPT is no longer valid. Star 5, if you have a follow-up question on this. Star 5. Okay. This one is from New York. New York, go ahead, please.
Hello, sir. So, as you are saying, the amendment I have to file, but like my employer is saying that the original employer that you should not file the amendment now, because if you file amendment, you will not get the stamping, as you are saying. That's correct. So he's saying that I should travel on my original, like the California location, and I should get stamped from that location, my current one.
It's a little fraud. If you want to commit fraud, go ahead.
Yeah.
But it's 5 years in prison and a permanent bar from entering USA.
Okay. Okay, so you are saying that I should get the
Right.
amendment
And
premium.
I'm the one who has a license to
But
practice law. Your employer does not.
okay. So the second, I mean, I have just one more question. That
Sure.
the thing is, I cannot file amendment, right? Because the status is still in pending.
You know, here is the practical solution. First of all, your
Okay.
OPT is still continuing, right?
Yeah, it is.
Okay. I personally feel the smart thing to do would be to contact USCIS and see what they recommend. I would actually file an amendment even while the first case is pending.
Oh, so we can file the amendment even
That's
if
what
my H1
that's what
is
I would
pending?
do. This is one of those areas of the law where we don't have bright line rules, but it would be my intention to go ahead and file an amendment. That's what makes sense to me.
Okay.
Okay.
So for that, I have to contact USCIS.
Your
And
lawyers,
I mean, I just want to make sure there is a law.
Your lawyers or your employer should contact USCIS. Of course, you can too, and just ask them what do they recommend you should do in these circumstances.
Okay, sure. Thank you.
You're welcome. Good luck.
Thank you.
Okay, let's go on to the next regular question. Oh, by the way, somebody had posted a question about political asylum. I'm sorry, I don't do anything with political asylums. Last time I did a political asylum case was before 1993. I think I did only one political asylum case in my life in 1989. So please don't wait. I will not be able to answer your question. Next question is from ACH Vic. EB1C eligibility process. I'm in the US for the last 2.8 years on H1B computer analyst. I was in a lead role in India. My employer is suggesting to change my designation on H1B petition from analyst to manager. I'm doing managerial job for the last 2.8 years in USA. Is it legal to have manager designation in H1B? No, not at all. Not at all. The designation in H1B is not relevant. Look, I see a couple of issues here, which are not what you have asked me, but because I see them, I'll point them out to you. First of all, if you are working in a managerial position on an H1B, your salary for H1B should be at that level. Okay. So assuming that that's taken care of, is it required to have an H1B title of a manager to file an EB1C? No, it is not. You can actually file for an EB1C as long as you have an offer of a managerial position. And because you are working for the same group of companies, even though you entered 2.5 or 2.8 years ago, your 3 years within which 1 year you must have spent outside USA working as a manager goes back from the date you entered USA. So I'm not going to make it very complicated. As long as you worked as a manager in India for 1 year at least before you entered, and as long as they offer you a managerial job in USA, you can file an EB1C directly without doing any amendments. That's the bottom line. *5 if you have a follow-up question. *5. Okay. Let's go on to the next question. Now this one is from Kaustab T. I'm holding an Indian passport and have come to Japan through my Indian employer on a work permit. Is it possible to apply for H1B from Japan on my own? First of all, you can never apply for an H1B on your own. But another employer, if they want you to come here on H1B, they can apply for your H1B and you can interview at the US consulate in Japan. You don't have to come back to India. So your employer can file for you. You cannot file an H1B for yourself. *5 if you have a follow-up question. *5. Okay. Next one is from Mitali Kashyap. I have discussed my query in one of your conferences in August or September. This is a follow-up. Quick brief again. My visa H-1B valid till December 2017. I-140 approved through employer X. Employer in January 1st week 2017. Priority date of June 2014 from the previous employer. Ex-employer is based out of USA but operated majorly from recruiters sitting in India. Ex-employer does not file fresh H-1Bs. They only do H-1B transfers. And they promote themselves for candidates looking for H-1B transfers. Pay stubs. Ex-employer generated pay stubs from Jan 2017 to March 2017. Medical insurance from Jan to March shown being deducted. No pay stubs paid to me in 2017. So they generated the pay stubs but didn't give you any money. That's what I think you're saying. You complained to the Wage and Hour Division. You returned to India in September. When Wage and Hour Division reaches out to ex-employer for your claim, ex-employer says, they lie of course, that they have sent a notification of termination of my employment to USCIS and they are ready to pay the cost of the ticket back to India. And this was done over a telephone. Okay. Is this a retaliation? Oh, I haven't really researched this law. Retaliation usually happens when an employer takes action against you for now look, I'm giving you a very generic idea of the law. You'll have to research this. I don't know off the top of my head how retaliation applies in cases where you already left the employer. So if the employer fired you because you filed a complaint, that's retaliation. But if you already left the employer then filed a complaint, I don't see retaliation here. That's the best guess I can make. Then investigator says you're not available for work now. This is not a retaliation. Yeah, exactly. That's what I think too. But why is it not a retaliation as there are only 2 months left for my H-1B to be valid? But you left USA, right? So if you left the employer, you're not really available to work and there can be no retaliation. There may be other grounds. I don't know if this is some kind of a constructive retaliation. The fact that the employer didn't pay you, I think, is a pretty serious problem. Okay? And there might also be fraud here. Because if the employer generated the pay stubs and didn't pay you, I think that's IRS fraud. That could be USCIS fraud. You could reach out to these two agencies also. Then they said there was a reinvestigation. Your current investigator did not investigate. You should reach out to their supervisor. Okay? If you feel that your claim has not been investigated properly, you can reach out to the supervisor. You can even write to the Inspector General. The way it works is every government agency has an IG's office. So there's an Inspector General's office with the Department of Labor who can investigate problems created by their investigators. Like if they have not done their job right or if there's systemic abuse. So you can write to the IG's office also. And yes, there's a potential for criminal penalties here, definitely. Okay. Star 5, if you have a follow-up question. Star 5. So I would say you reach out to their supervisor, investigator supervisor, as well as the IG's office, the USCIS, reach out to the IRS, tell them this is what has happened. All of this sounds pretty fishy to me. Okay. Rahul Sharma, H-1B and I-94 expired. Employer filed for an extension before expiry, got an RFE. They responded to RFE. H-1B amendment for client change was denied. They filed an MTR. Now employer B is giving me a job offer. Can I do a transfer? Okay, look, here is the problem. You've got to look at your I-94 expiration. If the I-94 expiration occurred less than 180 days ago, you can leave the United States and have another employer get your H-1B. I'm worried about your 310 bar issue. Okay. Now, as long as you have a timely filed extension application pending, your I-94 expiration doesn't really bother me. But from the date it is denied, you start accruing unlawful presence 180 days from the date of denial, you are barred from entering USA for 3 years. So it becomes problematic. Have a lawyer look at your situation, but having another employer apply while you are awaiting the result of an MTR is no problem at all. The only problem is the 310 bar. Look into that. *5 if you have a follow-up question. *5. Okay. Mithilesh Singh. My wife first came to USA on H4. Went back to India in April. Found a consulting company to file H1 while she was there. She got up in the lottery. Came to USA in October but could not find a project. She was on bench. She found another project in February, worked for 3 weeks. In 2016, she was pregnant. We decided to move to H4. We went to Tijuana and she entered on H4. Sounds okay to me. She got a new I-94 till June 2017, filed for an extension. Went to India for stamping. Mine was approved and hers went into admin processing. She received a call from Kolkata consulate for face-to-face. The visa officer asked her, "Did you work for the first company?" She said yes. Then the visa officer asked her about my work and profile, took 10 minutes and came back with a letter. "There's a serious hit against your visa. We cannot give you your visa." VO officer gave her 6 CI, I don't know what that means, and said she can apply for a waiver. What are my options now? Now this is very tricky. This is not something, Mr. Singh, that I can advise you in an open conference. I think what you should do is, first of all, you need more facts. Just because somebody says these cases get very complicated, I've had experience with these cases. Some of them took me almost a year and a half to get straightened out. My first approach is I want to find out what is the fraud. So I will contact the consulate. I'll say, give me a copy of the fraud documents. Tell me what the fraud is. Okay. And that goes on for a few months, give and take. Because the waiver, which is a 212D3 waiver, it requires us to say that we have committed fraud. I don't see why we should admit to any fraud if we have not committed any fraud. There's no fraud here that I can see. So I'm not sure what's going on here. I would advise you, get yourself a lawyer, be prepared for a long fight, and let's see how it works out. I don't know what's going on. Difficult for me to give you advice without looking at what the government's claim is. *5 if you have a follow-up question. Going on, oh yeah, there is a follow-up question. Okay, let's go to that. And this is from Texas. Oops, I don't know what I did. Oh, 1 second. 1 second. I have a touch screen and I'm not used to that right now. Okay, yeah, go ahead. I have unmuted you. Texas, go ahead. What did I do? Yeah, you are unmuted. Texas. Huh. What happened? Okay, let's try it another way.
The conference is now in conversation mode.
Okay.
The conference is now in presentation mode.
Can you press *5 again? I just redid the conference. Okay, excellent. Okay, you are unmuted. Go ahead, please. Sir, go ahead. I can't hear you. Go ahead. Huh. Okay.
Hello.
Yes, go ahead, sir.
Can you hear me, sir?
Yeah, I can hear you.
Yeah. Yeah. Actually, my wife replied to the question where she was asked if she worked for the first company for which her H1 was filed.
She did, right? She
replied,
worked
yes.
for 3 weeks, right?
No, that was the second company. She could not work for the first company.
Oh. That makes it a lot more complicated.
And
yeah.
Yeah, and later on we asked her employer as well, and they said that they did not file the LCA when she moved to the new different company.
Yeah, but I'm not sure that's still fraud, because there's a couple of things here. First of all, the fact that she worked without authorization or even illegally on an H1 is no ground to stop her from getting an H4. Okay, so if she lied, even if she had lied, that is not a material misrepresentation, because it has no effect on the outcome of the H4 visa. That is something that should be argued. So yeah, like I said, get busy for a lengthy debate with the US consulate. See if it can be resolved. Otherwise, just get a 212D3 waiver. The problem is, if there is a fraud finding, that's a permanent bar from entering USA. Even if you get a 212D3 waiver, it only allows you to stay here temporarily. It doesn't allow you to get a green card. This is a permanent bar, so it has to be taken very seriously.
That's right.
Okay.
So how do I get the details about the fraud documents from consulate?
I think you need to get yourself a competent lawyer. This is not something you can handle yourself. If you have a good company lawyer, tell them to get involved. I would definitely not want you to do it yourself. This is not something you can do it yourself.
Okay.
Okay. Good luck.
Yeah, thank you.
You're welcome. Okay, so next question is from Prasad 99. I think we already covered that question. Right, I think we did cover that. Now, Sri UK, I'm on 6th year of my overall H1B tenure. Current H1 has 10 more months validity. I-140 got approved last year. Project is ending in California. You're going to go to Washington, 3-month project. Then there's a possibility of relocation back. H1 amendment is needed, yes. You'll have to do an H1B amendment. There is no special dispensation for your situation. So yes, you have to do an H1B amendment. Star 5 if you have a follow-up question. Star 5. Okay. Let's see. There are 2 questions.
Yes. Hello, Rajesh sir.
Yeah, California, go ahead, please. Go ahead.
This is the question I will make.
Right. Sir, I can't hear you. You are fading in and out. Hello? Hello? I can't hear you.
Hello, can you hear me?
Yeah, a little better. Go ahead.
Hello, sir. This is the question I only posted.
Uh-huh.
Hello, can you hear me?
I can hear you. Yes.
Yeah. Sir, I'm not sure whether that information is correct or not. As per my friends and colleagues' information, LCA, even though if it is a short-term project like 1 month or 2 months or 3 months, LCA changes, it's a mandate. But I came to know, is there any grace period for H1 amendment?
No.
Only LCA
No, there isn't.
changing?
There isn't.
Okay.
There isn't. There is something called short-term, something like short-term placement exception, which is that if you have a long-term project in one place, but you need to go periodically to another place, you can do that for up to 30 days in any one location for any 12-month period. So let's say you have a project in California, but every 3 or 4 weeks you have to go for a day or 2 or even a week to Washington State. That could be covered by that exception. But if your project itself is in Washington, there is no grace period.
So suppose even 1 month is Washington project, what is that case?
I think that is still a problem. I think it requires an H1B amendment because that is not the intention of the regulation as far as I remember. The intention of the regulation is your project is in location X, short-term visit to location Y, A, B, C, as long as it is less than 30 days total over a 12-month period. So, but the project has to be stable in one position. If your project itself is in Washington State, you've got to do an amendment. There's no grace period.
Okay, sir. I have another related question. Suppose there is a case, Washington project in 3 months. We filed a LCA and as well as H1 amendment in a regular mode. Suppose usually the H1 amendment on average it might take 3 to 4 months, some cases 5 months as well. Suppose during the H1 amendment in progress stage, my project is over or due to other reasons, if I want to relocate back to California and I want to then what is the case? If I can revoke that Washington H1 amendment, will my California H1 is valid, or again we need to do any additional process for that California H1?
I would have to check that with the USCIS if I were you, because the way the government thinks about these is that if you had, for example, if your amendment was denied, the regulations specifically say that you can go back to work for the old location. So if you look at the regs, I'm quite sure they actually now specifically say that. Okay, so what is the difference between that and withdrawing and going back? I do not know. So the answer to your question is, amendment is necessary, but to go back and work at the same location for which you were previously approved, do you need to do another amendment? I'm not sure. I will have to check with the USCIS and go by what they say. Typically, when you call USCIS with a complicated question, they elevate you and they take you to one of the adjudications officer. Advice you get is not always reliable, but at least you got advice from the USCIS. Write it down, write down the date and the time of the call and the name of the officer or the number they give you. That way, at least you have some protection. My best guess is you can withdraw the H1 and join the same location. Now, if you're even changing the location, seriously, even though it is in the same metro area, if it's a different client, your employer should file another amendment to get you back to California. Okay? Hello? All right, I think I lost him. Okay, let's see. Is there any other question? No. Okay. So, let's see what other questions there are. Do I need to do an amendment for L1A visa if my office location changes? It's a difficult question to answer. I am facing that situation myself for another client. The law doesn't seem to require an amendment, but I'm still not sure. Over the weekend, I'm going to look into it, have your lawyers look at it. The regulation seems to say you have to file an L1A amendment only when your eligibility is affected. So if there's a change in your circumstances which affects your L1A eligibility, then you've got to do an amendment. Normally, a change of location has nothing to do with L1A eligibility. My guess, amendment is not needed. My guess. But don't take my word for it. Have your lawyers independently review it. Let me take a look at the last question. I see that there are a couple of people raising their hands. But I got to get through these questions, guys. I'm running out of time. So I'll get to you. But let me just finish this up. Asylum. I don't know anything about political asylum. I told you that. The last question is, I'm on my 4th H1 with I-140 approved. I-194 has expired in October 16. I got married to someone who was born in Nepal. So I can file for 485. In the event my H1 gets denied, my 485 will be done in consular processing. So do I have to go to India or Nepal? Oh, you can go to India. Cross-chargeability doesn't require you to go to their country. You can still do your processing, consular processing in your own home country. But I'm concerned about your I-94 expiration. Because if your I-94 expired so long ago, As long as your H1 was timely filed and still pending, you are okay. But if you have a 3-year or 10-year bar issue, then you've got a real problem. Okay. So to answer the question you asked me, do I have to go to India or Nepal? You can go to India. That's not a problem. Okay, guys. I'm only going to do follow up on the questions that have been posted. No new questions. I see that we've got a bunch of hands up. So let me go in the order that you called in. So first person I'm going to go to is Memphis, Tennessee. I won't have time. There's 4 questions. Definitely I will not have time for new questions. That much I can tell you. We're already over the time. So let's begin with Memphis, Tennessee. Tennessee, go ahead, please.
Hello. Unfortunately, sir, I have a new question. So
Well, you've been waiting a long time.
It's a short one.
You've been waiting a long time. Go ahead.
So we're planning to file a green card for my parents. So it's family-based green card.
Okay.
So the issue is that they don't have a marriage certificate. So what's the other document that can be an evidence in lieu of the marriage certificate?
That one is easy actually. What you do is you get 2 affidavits from people who attended the marriage, that I was at the marriage, they were both there, and those affidavits along with secondary evidence, like they must have mentioned each other in their passports as their spouses. Normally the 2 affidavits are enough, because remember, under the Indian Marriages Act, well, there were 2 kinds of laws. Assuming your parents were Hindu, there was no requirement for any registration.
Yeah.
Only if you did a civil marriage, you went through the court system, you had to register. And most people did religious marriages. So we didn't have any registrations in the old times.
Right.
Okay, no worries.
Okay. One other one. Can I ask another
Make it really
quick
quick
question?
because I got 3 other people waiting.
Yes. Sure. The other one is that now they're in India. So we are planning to file 130 now. So in general, how do you advise? Should they come here and then we file 130, or you can? We were thinking of filing in general.
I've discussed that issue many times. If you look at our frequently asked questions, if you use a tourist visa to enter USA with a preconceived intention to change to green card, that can be considered to be fraud. Okay. So look at the frequently asked questions. We have this discussed no less than 3 or 4 times in detail over the last 6 months. If you still don't get your answer, if you don't get your answer, post the question for the next conference call. I'll talk to you in 2 weeks. Explain it to you. Okay?
Okay. Thank you so much.
Good luck.
Thank you.
You're welcome. Okay. Let's go to skip this. Put back on mute. I've got 3 more people. So this one is, again, I'm going in the order that you called in. This one is from Chicago. Chicago, go ahead, please. Chicago.
Hey, Rajiv, one quick question. So coming to that amendment, so if we change clients but then like the same city, I know we don't need an amendment at that point, but do we need a new LCA?
No, I don't agree. I think USCIS has screwed up in giving us incomplete directions. They have said that when you are relocating within the same metro area, you don't need to do an amendment. But they should have said as long as everything else is the same. So the end client is the same, the project is the same. If you move projects or if you move the end clients, I think you should do an amendment, even if it is in the same building.
Okay.
Now, if you are working on the same project and the project and the end client moves to another building 40 miles away, no problems. No amendment necessary, just the LCA is enough. But if your project changes, remember, the entire employer-employee relationship could change, your job description could change, so you need to do an amendment in those cases. Government has misguided us. Okay?
Right. Yeah, they're not always right.
Yep. No, they're not only not always right, they're not always complete. In fact, immigration law is so messed up, many times the first time even the laws are passed, there are lots of typos. Then they have to issue a technical correction act. This has happened so many times. So you imagine so many eyes review the laws, they can still have typos.
Okay, thank you.
You're welcome. Okay, let's do the last two people. And I just unmuted you, sir. You're from California. California?
Sir, I have one follow-up.
Yeah, go ahead, please. California.
Sir, and suppose within the same city, you said MSA zone. Suppose I'm working one state, department of one state, and within the same MSA, within the same city, if I am changing to a different state project, state government project, is it will consider the same client or different client? In that case, H1 amendment is required or not required?
I think this is a very interesting question. I had a similar situation. And I tell you what I told my client. I said, look, your end client is the same. The master services agreement under which you are working is the same. So the employer-employee relationship has not changed. The project description is the same. The only thing is, in one place, you were supporting the Oracle functions of one department. Here you are supporting the Oracle functions of another department. So it's the same job. I don't see any problem there.
Sorry to interrupt you, sir. The example, suppose I'm working for a state of California Department of Transportation, and within the same city MSA zone, I'm changing to a Department of Healthcare.
I'm okay with that.
And the client point of view, both are state government.
Yeah, that is fine, as long as it is the same master services agreement. The employer-employee relationship has not changed, and your job description is the same.
Usually the case, sir, MSA might be changed because the employer and each and every individual job ID have their separate MSA, and I guess it's a separate contract, I guess.
I would like to do an amendment in these cases because I don't know.
Sorry, sir?
I recommend an amendment because I don't know how the new MSA reads. Okay. So in cases like this, I would definitely advise an amendment is the smart thing to do. Okay. Now, if somebody says, look, everything about the MSA, the language is the same. The MSA might change, but it's the same language, same end client, same project description. I think LCA is enough. But if anything that obtains a change, there's a change in your job description, government needs to look at it and say, well, this is not a specialty occupation. The old job was, but this one is not. Or the relationship has changed here. It looks like the state government has a lot more control on you now. So that's why I think government has not given us a complete picture of what they want us to do. The regulations say any substantial change. And what is substantial? Substantial is anything that affects your eligibility to the H-1B. Okay. So I don't know. It's really a matter of being how conservative you want to be. It's the employers and their lawyers' call, not yours or mine. If it was my client, I would want to look at the MSA. I would like to look at the job description and then make a recommendation. Okay?
Okay, sir. Thank you very much, sir. Great information.
Good luck. And the last question for today is also from California. Today we have a lot of callers from California. California, go ahead, please. Last question of the day.
Hello, sir. I have a follow-up question. Where my I-94 was expired in October. So my question is like, when I go to India or India, for example, do I have to go there with my wife?
Okay, 1 second. First thing I want to know is, your I-94 expired in October last year. Okay.
Yes.
Is your H1 still pending?
Yes, the RFE, like, they were going back and forth.
Okay.
So RFE is still pending, and the lawyer said that most likely they will reply with accept or denial now.
Okay. But there was never a time when your I-94 was expired, but there was nothing timely filed. So if you have an H1 pending, you don't have the 3-year, 10-year bar problem. But please discuss it with your lawyer before you make any plans. Okay? Make sure that you don't have any 3-year, 10-year bar problem. Now, if that is out of the way, let's get rid of that because that's the most problematic area. What was your question? Let's look at your question again, please.
Like in the event if the H1 is denied, my I-485 will be done in consular processing. So like my first question, you already answered that,
Right.
whether I have to go to India or Nepal. You said I can go to India. Do I have to take my wife with me? Because I'm using cross-chargeability.
The answer is no. She does not have to go with you.
Okay.
Does she have a green card? What is her status?
No, she's on a visitor visa.
She's on a visitor visa. She doesn't want to get her green card?
Yeah, so like, I already submitted the paperwork and we filed for for our 485 together.
The law does not require her to go with you if you want to claim cross-chargeability. There is no such requirement.
Okay. Okay, cool. Thank you.
Oh, you're welcome.
That's it from my side.
All right, sir. Good luck. Let's just... All right, folks. It's good talking with you. I am always very, very grateful that I can help. I'll talk to you again in 2 weeks. You have any questions, please post them. Because if you post them, I am definitely going to answer the posted questions. Other new questions, as usual, we run out of time, so we don't have time for new questions. Good luck, everyone. Talk to you in 2 weeks. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.